Come on, buddy.
Good morning.
Good morning, Judge. How are you today?
Good.
How is the heat down there?
It's a few degrees cooler. It's 104 instead of 109. That's about it.
That is improvement, I guess, but geez, you guys are soldiers down there.
I've never seen anything like it. And we had the record low temperatures in May. I dug my sweatpants out twice.
Oh my.
Tried to put them away, and then we have it followed up by 4 months of August.
Well, I hope it breaks soon.
I think starting Monday or Tuesday, the 10-day forecast shows everything at least in the 90s after that.
Hallelujah. That's really good. Let's hope it stays there and doesn't pop back up again.
Yes.
I'm going to put you on mute. I have a dog in my lap and he is snoring very, very loudly, Judge. So I don't want to distract from the hearing.
Okay, I see there's some motions. I was in the office until after 5 yesterday, but I guess I didn't check my mail after 4:50 something.
Yes, Mr. Morales' office filed opposition to our motion.
Yes, and I think this is the response, so.
I noticed something came through this morning.
I have a link to a Dropbox. Was that from y'all?
That wasn't from us. I believe we sent a revised order this morning, not too long ago. So that's probably what was being referred to earlier.
That's correct. Thank you for that, Roy.
Sure.
All right, give me a moment here. Okay, so I have the Korth heirs response to the motion for partial entry of partial judgment. And was I sent the Eckford heirs motion for entry?
Yes,
Um,
Your Honor.
you should have that.
I will.
I want to say it was file stamped on August 17th.
Oh, well, I may have gotten it.
I can email it to you, Judge, if you need.
Okay, let me see here. Okay, this is all meetings. Yes, if you would email it or post it in chat.
Yes, sir, I'll email it to you.
And Judge Wilson, do you have the revised order that was filed this morning?
No, I've only received one email that came through this morning. That was from Judge Dillingham
Okay.
All right,
on
Marcus,
a juvenile board matter.
go ahead and send that as well, Marcus.
Correct. Yeah, Judge, we filed a revised proposed order this morning. It hasn't been accepted yet, but I'll send you what we have.
Okay. And I had my judge's queue cleaned out yesterday morning, or yesterday afternoon, so I don't believe there's anything in there unless it was put in very late.
All right, Judge, I just emailed you.
Okay, and I received that email. Okay, and a bunch more folks are coming in. If you'll give me just a minute here. Just trying to save everything so I have it to look at. Okay, so I have the Eckford heirs motion to enter a partial judgment. And was the proposed order changed, or is there a revised or updated motion to enter judgment?
The order was revised, Your Honor, not the motion. I believe Marcus sent that to you in the chat, right, Marcus?
By email. I've received that.
Okay.
Reiterates what was in the motion.
So there's a modified order. I have an order that was filed on August the 17th.
Yeah, that was the original motion and order, but we filed a revised order this morning.
Okay, take a look at that.
But the revised order states verbatim what's in the motion, so you could go off the motion as well.
Okay. All right.
And to be more accurate, Judge, it shouldn't be called a partial judgment. It should be called a special verdict. It's in compliance with Rule 290 and 300.
Okay.
Rule 300 states that where a special verdict is rendered, the court shall render judgment thereon unless set aside or a new trial is granted or judgment is rendered notwithstanding the verdict or jury finding. And in this particular case, it's a case out of Houston, Anheuser-Busch versus Smith. The court was authorized to issue the writ of mandamus to compel a district court to proceed to trial and judgment in a cause. And necessarily this court has the authority to order the trial court to accept an order filed a proper verdict after it has been returned by the jury to the court. So in that case, the trial court should set aside its order of mistrial and order the verdict of the jury filed and enter the judgment required by the facts as found by the jury. And that's essentially what we're asking for in this case, Your Honor, is that sort of special verdict. And the judgment is in compliance with all the issues that were decided. And those issues are conclusive evidence of essentially all the claims that the experts were seeking, some of which still have fact issues, obviously, and can proceed to trial. And we're looking to have a trial date right after Thanksgiving that should allow plenty of time for discovery and motions for summary judgment.
All right. So do you want to just, how do you want to do this? It's the plaintiff's, the expert's motion. You want to start with that or?
Yes, Your Honor. Essentially, we're asking the court to simply enter a judgment per the jury's findings. And, you know, these findings weren't necessarily general. They were conclusive as to all the issues that were being tried in the case, including the claims of the expert errors. And so the order that we have proposed is in compliance with the jury verdict and also addresses the untried claims not submitted to the jury, which can be set for trial now that the jury has found what's in the proposed order.
Okay, and who's going to speak for the fourth errors? Pardon me, the expert. Yeah,
The court's, Your Honor.
of course.
Yeah, Your Honor, Ricardo Morales on behalf of the plaintiff interveners of the courts. So we did file a response yesterday with this request to enter a partial judgment. We cite to Rule 301 there can only be one judgment in a case. Only one final judgment shall be rendered in any cause except where it is otherwise specially provided by law. And so we're at a phase where there are other issues that need to be resolved, and those issues will be part of that final judgment. And so we don't think that entering a judgment at this time, we think it's premature. It wouldn't render any appellate deadlines or move the case towards closure any faster. We're still, I think, waiting for the record. And so since we've got these other issues that are out there, we just don't think a judgment right now does anything to move the ball since there can only be one judgment. And certainly we'll work with Mr. Elizondo and his team to enter a judgment. In addition, the motion didn't actually have a proposed judgment. It just had language in the motion. It's got some serious problems that we have with the form or with the language that they've proposed. Specifically, there was a settlement to 40% of the 1736 that was in dispute in 2016. And as a part of that settlement, that settled portion was severed out into a new cause number, and we've attached the judgment that was entered in 2016. It was a modified agreed final judgment, and it gave the courts 40% of the 1736. That judgment, of course, wasn't appealed. It was part of a settlement. There were quick claims that were exchanged. I'm sorry. And so there were quick claims that
Mr.
were
Ross, I'm not sure that came from our meeting. I didn't see anybody else light up. Sometimes I've seen cross feed where I've had everybody muted, including myself, and we still have chatter. Go ahead.
Okay. And so we still have that judgment. So whatever final judgment gets rendered in this case, we'll have to deal with that and specifically exclude that settled portion of the interest, because that's already been resolved. That was resolved back in 2016. So essentially, what we'd like to do is propose that we enter a scheduling order on these pending other issues, and let's get them resolved, and let's get a final judgment in place, and then that'll trigger the deadlines for any post-trial motions and appellate deadlines as well, as opposed to having this sort of partial judgment that's not really a judgment there. So that's the position of the court, Judge. We don't think it moves the ball, and we think we've got these other issues that need to get resolved.
Okay, but I think we have to have either whether it's an informal agreement or a special verdict or whatever. I think we need to have some kind of bright line as far as what the ground rules are going forward, so that we aren't having a dispute about what needs to be tried later this year.
That's exactly right, Your Honor. So we're on the same page as that, and entering a judgment per the jury's verdict will establish the relationship going forward, so that we can just conclude with any remaining discovery and any motions for summary judgment, which, there shouldn't be really any fact issues going forward, but we'll see once the discovery pans out.
Well, Judge, I mean, we do have a ground rule. We have the verdict. I mean, the verdict is the decision by the jury. So that guides us already. We know where we are on the judgment. We have a judgment that was issued as a result of the court's prior summary judgment that was entered. And so essentially, I think that what that judgment will look like will be a mirror image of what was done by the court earlier in the case, plus the resolution of any of these other issues. I don't foresee a big fight over what that judgment should look like. That motion that was filed does have some other issues in addition to the fact that it doesn't recognize that a portion has already been settled out. It talks about granting of a motion for summary judgment. That's in the proposed language. And so that the court denied that motion for summary judgment. But we've been down this road before. It's been plowed. So we know, I think, what that judgment should look like, plus whatever it is that Mr. Elizondo and his team end up with on their accounting claims and some of these other accounting claims. So we have our guidance, we have our verdict. And so I just don't think that a partial judgment is necessary.
Okay, and let me go and look at my calendar.
Until that judgment is formally entered as it's required as a matter of law and it's mandamusable, Your Honor, there's no official precedent going forward with the law in the case, which has already been decided by the jury. So,
well, I don't think that, Rule 300 is trumped by Rule 301, that there can only be one judgment. I mean, that there's, and I think what Mr. Elizondo was talking about that for some reason this judgment should be mandamusable, or this partial judgment should be mandamusable. I mean, that still doesn't move the ball. That does is, if that's what they want to do, they're going to want to mandamus at this point. Then all that does is delay us when the result is going to be the final judgment once these other issues are resolved. And I think what Rule 300, and this is the first we hear about Rule 300, it wasn't cited in their motion, but it says where a special verdict is rendered or the conclusions of fact found by the judge are separately stated, the court shall render judgment thereon unless set aside or a new trial is granted or judgment is rendered notwithstanding the verdict or jury finding under these rules. So this is the first we hear about a claim that this is somehow a special verdict. I mean, I don't think that we agree that it's essentially a special verdict. We've got just resolution of some issues, and then we've got more issues that we need to get resolved, and then that will give us our final judgment.
Okay, and did you look at the court schedule when you said sometime after Thanksgiving for a jury trial?
No, Your Honor. We were just hoping to get it as soon as possible.
I'm just looking here when we're going to have jury trial in Karnes.
We made some
Last week,
agreements.
I'm sorry?
You know, when we agreed to move to have some of these issues resolved later, and I think we have to go back and look in the record, but my recollection was that we had, or my expectation was that we were going to be going forward in front of the court with these issues, and not that we'd have a second jury trial. Of course, we have to go back and look at. I know we had a few discussions about this issue over the course of several of the pre-trials before the jury trial.
Yeah, Your Honor, we didn't waive our right to a jury trial, so if there are any fact issues that the court feels needs to be resolved, then we would proceed with the jury trial then. But there may not be, and everything may be resolved on summary judgment.
Okay, so let me go back and look at my calendar. There's going to be we had jury trial in Karnes last week. The end of October, there's going to be a jury trial. But that sounds like way too fast. That's 7 or 8 weeks away. And then after that, February 26th. With a docket call of February 1st.
That's fine.
Okay, and I'm thinking out loud here. Are there going to be motions for new trial or motions for JNOV from the course?
Yes, Your Honor, I would imagine that we would be filing post-trial motions once the judgment is entered.
Okay, I'm sorry, I just received a message. Are we on the record? From Ms. Cavazos, did you get that? Yes. Okay. Okay, I guess what I think would be best to do is I want to do some research on this. We need to have, whether it's just if the jury verdict is enough, that's great. We need to have some guidelines going forward on what's considered resolved. Can the attorneys get together and give me some more guidance on what needs to be resolved still? I see that there's a claim for reimbursement from back to 1939. And I've got to tell you, I don't know. I think that if you've paid taxes, you can go back more than 4 years, asking for your co-tenants to chip in on their taxes, but can they go back and litigate over a grazing lease in 1939 and whether they're entitled to, part of that 75 cents an acre or something? Or is it 4 years from when the lawsuit was filed? Or is that something you all are not agreed on and we need to settle that before we even start?
I think that's something that we could probably sit down with Mr. Elizondo and his team to try to resolve that issue.
Okay.
And
I
it'll take,
want to do some research on this, and what I would like the attorneys to do is sit down and come up with a list of what do you agree needs to be tried still in this case, and what do you have a disagreement about what needs to be tried, including any limitations issues.
Certainly, Your Honor, and should we have another hearing on it? Or
Oh, yes, absolutely. So
did
how
you
long
want
do
to
you-
submit some additional briefing regarding what needs to be entered going forward?
if you want to, and again, if y'all get it settled, by that, I agree with Mr. Morales that I don't think that anything I sign right now, it's still going to be interlocutory. But whether it's a special verdict or just an order I sign, just saying that here's what we're going to be trying in the future, or here's the ground rules as far as what we're going to take the facts to be. If y'all can agree on that, great. If not, then yeah, I think I need to make some kind of a ruling. But before I know how long I also need to know how long we need to do this. If you're talking about decades of going back and trying to get offsets for payment of taxes and staples to fix the fence, compared to whatever rentals may have been received, I mean, that could take a very long time. Probably with just to be blunt, the number of attorneys on both sides, it probably wouldn't be economically worthwhile going back too far. But
I think Mr. Morales and us can reach a business decision on that one, Your Honor. I wouldn't be too concerned with that. Well, I think we're on the same page.
okay, so how long do y'all want to do something like that? I mean, to come back to me, we'll have another hearing.
A week?
All right, so let me go and look at my calendar.
I think that's a little ambitious, Judge. 1 week to try to get the result, to start to try to work through all of those issues. If that's what the court's asking, to give the court an idea of kind of what I don't really know what this accounting claim is going to require on, with Mr. Elizondo, whether they're going to start taking depositions of the ConocoPhillips folks and that sort of thing. So, I think we need a chance to sit down with all those issues, and we can do that next week. And if the court gives us a little bit more time, we can come back to the court and say, okay, here we've identified kind of what the disputes are, and here are the issues that need to get teed up in front of the court before a trial date.
I think resetting within 2 weeks, Your Honor, would allow plenty of time, and the court could have all the information it needs within 2 weeks to start signing orders.
Okay, I've got. Okay, so let me go to my other calendar.
We are still good with February 26th, right, as the proposed trial date?
Okay, I have and y'all can talk about that. I have a civil date in Carnes, and y'all can appear by Zoom on the 19th. I will be back there. I'm not sure what time I'd be able to get to you on the 22nd for a dismissal for want of prosecution docket.
We'll take the 19th.
Would it be via Zoom, Judge?
Yes, you can appear by Zoom. I'll be in court, and it's just, this is my standard Zoom meeting number, so it'll be same number you used today.
And can we have an agreement with counsel that we will all appear by Zoom?
That's fine. We'll appear by Zoom.
Okay. All right, is that okay, Ms. Marks?
I have nothing else, Your Honor.
Okay, I didn't know if you wanted to come back here and get some more heat. Okay, so I'll make a note for the coordinator to set this on the docket by Zoom on, what did I say, the 19th?
Correct.
19th of September, 9 a.m. And we'll try to get a DCO, hopefully enter that day.
Excellent. Thank you, Your Honor.
Okay, y'all are excused.
Thank you, Your Honor.
Thank you, Judge.
Yes, sir. All right, Lachey, I will see you on Monday. I'm not even sure where we're going to be. Back in Atascosa. Oh, okay. We've got child cases. All right. I won't say any more. We're on the internet.